So we talked about, and we saw the great things. We're going to be having the 250th anniversary of the signing of the Declaration of Independence. It's going to be coming up on July 4th. None of this is news to you. And it will also be the 200th anniversary of the death of both Thomas Jefferson and John Adams. You can tell I love Thomas Jefferson. The guy's been dead for 200 years, and I still get broken up when I mention it. But yeah, it's the great irony of American history that sort of suggests that this truly is a providential nation. That God had a plan, and we're all part of that plan. So, with the 250th anniversary in mind, this truly is a great subject. This is birthright citizenship, which is what I'm going to talk about today, is truly a great issue. Because when you find out how we got to this point, it really tells you a lot about the United States, and it's probably going to tell you something about how the Supreme Court is going to rule. Guaranteed, if you want to put down money on anything, and I never bet, but I never bet on Supreme Court decisions, I will tell you that this one will be the last decision that they issue. Because in D.C., we have a thing called a ring and run. A ring and run is when you dump bad news and get out of town as quickly as possible. So there's a reason that the Biden administration would put out its border numbers at 11 o'clock on a Friday night, because the border numbers were always horrible. The weekend would come and people would forget about it by Monday, they hoped. That didn't actually happen. But I'm not saying this is going to be bad news or good news. I'm just going to tell you that half of the people interested in this issue aren't going to be happy with what the Supreme Court finds. Well, let's go back to the beginning. Let's go back to 1787. Let's go back to the Constitution. We always start with the Constitution. Article 1, Section 8, Clause 4 of the United States Constitution gives Congress the power to create a uniform rule of naturalization. And this was such an afterthought for the Constitutional Convention that they also say, oh yeah, you have jurisdiction over bankruptcy too. Because in the early stages of this republic, citizenship was important. They considered it. They considered it so important that in Article 1 of the Constitution, it says to be a member of Congress, you had to have been a citizen for 7 years. In Article 2 of the Constitution, they say that in order to be the president, you have to be a natural-born citizen of the United States. You had to have been a citizen at the time of birth. Curiously enough, there's nothing in the Constitution that says you have to be a citizen to be a judge. Interesting, they just left it out. But the one thing that they never did do was explain what citizenship is, what the rules governing citizenship are, and how those rules apply. It was an afterthought. And in fact, in the early days of this republic, citizenship was done state by state. Maryland had its own citizenship law. Virginia had its own citizenship law. And to this day, you can actually still be naturalized by a state court judge. That's how old this principle is. But there's nothing in the Constitution, not at the beginning, that talked about citizenship. A very famous case, largely forgotten, called Matter of M. Immigration cases, administrative immigration cases always begin matter of something. And M actually has a name. He was the Count DiMartino. And the Count DiMartino got into some legal trouble in the United States, and he overstayed his visa. He was from Italy. And then Immigration and Naturalization Service deported him, attempted to deport him. And he came forward and he said, wait a second, you can't deport me. I am a citizen. I'm a citizen of the United States because I am the great-great-grandson of the Marquis de Lafayette. And the Marquis de Lafayette, not born in the United States, never naturalized. But in the midst of the French Revolution, the Marquis de Lafayette, who actually designed the French flag, was taken into custody during the terror, and he was imprisoned. And the state of Maryland and the state of Virginia wanted to get the Marquis de Lafayette out of some horrible prison in terror, France, and bring him to the United States. So they both passed a law that said that Marquis de Lafayette is a citizen of Maryland, of Virginia. It didn't work, but it was sufficient to allow the charge d'affaires at the U.S. Embassy in Berlin to give his wife travel documents and his son travel documents that they could come to the United States. George Washington Lafayette was his son, by the way. So, it worked from that perspective. But when the Board of Immigration Appeals, considered the County Martino's case, they're like, yes, Lafayette was a citizen, but you're not a citizen, even though you are a direct descendant of him. You're getting deported because the citizenship law changed, and it actually, was refined. All of this story starts with a case we all learned in school: Dred Scott versus Sanford, 1854. Chief Justice Roger Taney writes for the majority in a case involving Dred Scott. Dred Scott was an enslaved person, and he was the property at the time of Dr. John Emerson. And Dr. John Emerson was a military doctor, and he took Dred Scott and he took his wife Eliza and his daughter Liz with him when he moved from post to post. He was posted in Illinois, and he was posted in part of the Wisconsin territory, which is now Minnesota. And Dred Scott sued in district court in Missouri. First he sues in state court, then he sues in district court. And he says, when I was taken to Illinois and the Wisconsin territory, I became free because under the Compromise of 1850, slavery is banned in those places. I didn't leave by myself, I was taken. You can't, I am now free. And we talk a lot about judicial activism. In fact, I had a conversation with my sister yesterday. Oh, this is being live streamed, isn't it? We'll skip that part. But, we talk about judicial activism. And this was probably the worst case of judicial activism, because the questions that Taney answered were not questions that anybody was asking. And what Taney said was, looking at the Declaration of Independence, and looking at the Constitution, and looking at the times in which we live, we're much more enlightened now than they were at the time of independence. But those people at the time of independence never considered that any enslaved person of African descent, is what he said, could ever be a citizen of the United States. Dred Scott does not have standing to sue John Emerson, because at that point John Emerson was dead. Sanford was his nephew. And two, you're not a citizen, and you can never be a citizen. Neither you or your descendants will ever be a citizen of the United States. And for good measure, he also said, oh yeah, the Compromise of 1850 is constitutionally invalid. No single action taken did more to lead to the Civil War than Dred Scott versus Sanford. Abraham Lincoln goes to Springfield, Illinois, 3 months after Dred Scott versus Sanford is issued, and he literally refutes line for line everything that Roger Taney said, because Roger Taney literally made it up. With respect to his contention that, we become more enlightened by the 1850s than they were at the time of the Revolution, Lincoln talks about Jefferson's first draft of the Constitution, of the Declaration of Independence, where he says slavery is an abomination and it should not exist in this republic. And one of the things that we are mad at the king about is that he has imposed on this, and that he has done this thing to these people who never did him harm. At the time that the Constitution was adopted in 1789, Lincoln noted, there were 5 states that granted blacks and free blacks the right to vote. They were New Hampshire, New York, New Jersey, Massachusetts. Does anybody want to guess the rest? The fifth one? It's not Maryland. Come on, shout it out if you want to make a guess. What? North Carolina. Blacks in North Carolina actually elected the representatives that adopted the United States Constitution. But the creation of the cotton gin changed the entire character of the United States, made slavery much more important, and all of those state laws ended up getting rolled back. If you ever have the chance, Abraham Lincoln, July 1854 speech, Springfield, Illinois, you really need to read it because it is probably one of the most inspirational speeches about America that you will ever read. It's 2.5 hours long, though, so you may want to get one podcast. In any event, as I said, it led to the Civil War, and we all know how the Civil War came out. And the Reconstruction Congress, the radical Republicans who were in control of the Congress, wanted to overrule Dred Scott legislation. And so what they did was they passed the Civil Rights Act of 1866. They wanted to make it so that everything that Tawny said was reversed, that every formerly enslaved person would be a citizen of the United States. And that the Civil Rights Act of 1866 begins. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. So Congress, for the first time in history, actually created a rule of citizenship. Not the Constitution, never existed before that, to overrule Roger Clark. The president at the time was Andrew Johnson. Andrew Johnson was a Democrat. He was he had been a slave owner in Tennessee. He was Abraham Lincoln's vice president on the National Union ticket. And Andrew Johnson vetoed the Civil Rights Act of 1866. Now, Congress overrode that veto, but they became very concerned that if they didn't put that citizenship rule into the Constitution, Democrats would take over Congress, they would repeal the Civil Rights Act of 1866, and all of those formerly enslaved people were going to lose their citizenship and were going to go back into a state of bondage. And they didn't want it. So they decided instead that they were going to create the 14th Amendment to the Constitution. And the 14th Amendment to the Constitution begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. A little bit different from the Civil Rights Act. That second clause, Civil Rights Act, not subject to any foreign power. 14th Amendment, subject to the jurisdiction of the United States. So that passed, it was ratified, it was actually part of the deal for former Confederate states to come back into the Union, was that they had to vote for adoption of the 14th Amendment. It became a law, but that term is vague. What is subject to the jurisdiction thereof? And if you read the floor debates at the time, they are literally all over the map. Nobody can really, depending on who you wanted, whose vote you wanted, you would tell them that it meant that. Very confused. A man named John Elk is a Winnebago Indian, and he's living in Omaha, Nebraska. He left the Winnebago reservation, and he went to live in Omaha. He paid taxes, he learned English, he dressed like everybody else in Omaha, Nebraska, and he goes to vote. And he goes to John Wilkins, who is the registrar of voters, and says, I want to vote, I want to sign up to vote. And Wilkins says, you cannot, you are a Winnebago Indian, you are not a citizen of the United States, you're not a citizen of Nebraska, and so you can't vote. John Elk sues all the way to the Supreme Court. And Justice Horace Gray writes the decision. Elk versus Wilkins, 1884. And Justice Gray says, in order to be a citizen of the United States, the citizens already in the United States have to consent to your citizenship. Now, there were a lot of Indian tribes who had signed treaties to become citizens of the United States. But there were a lot that hadn't. The Winnebago was one of those tribes that didn't. And so they determined that John Elk was not a citizen, that only with the consent of the government of the United States could anybody become a citizen. Fast forward 14 years later, and the Supreme Court issues a case called U.S. versus Wong Kim Ark. Wong Kim Ark is born at 751 Sacramento Street in San Francisco, California. If you've ever been to Chinatown in San Francisco, the 20 Sacramento bus runs right past where Wong Kim Ark was born. And he was born to two parents, both of whom were the 19th century version of green card holders. And he decides that he wants to go to China where he'd never been before. So he gets on a boat in the port of San Francisco, he goes to China, he's gone for about 2 months, and he comes back. And when he gets back to Angel Island, which was the immigration station in the port of San Francisco, the director of the port won't let him back in and says, you're not a citizen of the United States, you're Chinese. And this was during a period of time of the Chinese exclusion. And Wong says, no, I was born at 751 Sacramento Street. So he is held in detention, and he challenges the decision of the port director in San Francisco. Goes all the way to the Supreme Court. And the Supreme Court majority says, we've read the 14th Amendment. We're familiar with Elk versus Wilkins, but the way that we interpret this is everybody who is born in the United States, with 4 very specific exceptions, is a citizen of the United States. Those 4 exceptions are the children of diplomats, a child born in an area of the United States under military occupation by a foreign power, a child born on a military vessel of a foreign power, and Indians. If you're a member of an Indian tribe, you're not a citizen of the United States, even if you were born in the United States. And curiously enough, the same judge who issued Elk versus Wilkins, Horace Gray, was the same guy that wrote Wong Kim Ark. 2 very different sort of decisions, but that's the way that the decision came down. Now, here's why I say that this is a great subject. It's a great case for us to talk about on the nation's 250th anniversary. Because here's how Horace Gray got to this conclusion. Horace Gray got to the conclusion that subject to the jurisdiction thereof only had those 4 exceptions. Not by looking at the Declaration of Independence, not by looking at the Constitution, not by looking at the founding of the United States. He does it based on English common law, feudal law, the law of fealty. If you were born on the king's estate, the king owned you, and you owed him an obligation to do whatever he wanted. He had to protect you, but you had to do whatever he wanted. That was the law. And in fact, Justice Gray uses the phrase, the fundamental principle of the common law with regard to English nationality was birthed within the allegiance, also called legality, obedience, faith, or power of the king. Such allegiance and protection were mutual, as expressed in the maxim, protectio propit subjectionem et subjectionem protectionem. Father Kerr, who taught me Latin, would probably be turning over right now if you heard me say this word, because my pronunciation is not very good. But what that translates is, protection creates subjecthood, and subjecthood creates protection. Horace Gray ignored the fact that we broke away from Britain because we didn't want to be British. That we broke away from the British crown because we weren't subjects, we were citizens, free-born citizens of the United States. Chief Justice Fuller, in dissent, hates this decision, hates it. He rejected the application of that English common law of legality, feudalism. finding that citizenship in the United States is a political idea guided by public law, not feudal allegiance. Subject to the jurisdiction means that the person must not be under the sovereignty of any foreign nation, and permanence of residence doesn't apply to travel. If you are a sojourner, which was the term that he used, passing through the United States, if you are, not here lawfully, you are not a citizen of the United States. This is what Chief Justice Fuller found in the dissent. And it was a 7-2 decision, so 7 of the judges went along with Brett. If any of you listen to the oral argument in Trump versus Barber, which is the name of the case that's going to come out as the last case of the year, I guarantee it, you would have heard Solicitor General John Sauer talk about sojourners a lot. And he talked a lot about the immigration laws of other countries and how they treat people who were born in those countries. And at one point, Chief Justice John Roberts, who I'm convinced didn't actually read any of the briefs in this case ahead of time, asked Sauer, why are you talking about what they do in the rest of the world and not what we should be doing in the United States? Because that's the point. And the point that he makes, and there's support for this at the time of the adoption, is that we were creating in the 14th Amendment a uniquely American citizenship law that was unmoored from feudalism. If you listen to those arguments, you would have heard Justice Barrett ask about those Indians who weren't citizens. She asked Cecilia Wong, who was the attorney for the ACLU, which is arguing on behalf of Barbara. Barbara's a pseudonym for mother of a child in the United States. Asked Cecilia Wong, did those Indians carry around a bubble around them so that no matter where they gave birth, that child wasn't a citizen? It's actually probably the most interesting question. Now again, when Horace Gray wrote this decision, he's like, you do everything else according to common law, according to Lord Blackstone and what Edward II found in 1462. So we're going to do that for this as well. And the crucial point that Sauer made was, here's how I can prove to you that that's not the right law. There are no Indians in England, certainly not in feudal times. So how in the world could they have carved out this specific exception based upon English common law for a concept that didn't exist under English common law? Now, by the time this decision comes down, I have a feeling that John Roberts will actually take a look at the briefs. And again, I mean no disrespect, they got a busy guy talking. But I think that one of the things that if I had to make a guess, here's how that decision is going to come down. And remember, the only reason that this is an issue is because the president, on his first day back in office, issued an executive order that gave executive officers, the Secretary of State, the head of HHS, various other people, marching orders that beginning on the date that was 60 days after the date that he issued his executive order, that they had to make sure that no one was recognized as a citizen of the United States unless they were born to a citizen, unless they were born to a green card. Those are the only people. If you're in a non-immigrant status, if you're a student or you're a tourist, you don't count. If you're here unlawfully, both the parents, not one, but both, you're here unlawfully. Interestingly, when this came up the first time, this is actually the second argument because the first decision overturned universal injunctions. But Justice Kavanaugh, is anybody here a doctor? Anybody? I don't need a doctor, but I'm just asking. One of the questions that Kavanaugh asked is, well, what are doctors going to do if they adopt this rule? Now, I trust that many of the women in this room have been mothers, and you were actually there when your children were born. You know who doesn't have any say at all over who's a citizen of the United States? The doctor who delivered your child. There is The doctor doesn't check a box that says this child is a citizen. The doctor checks a box that says, in my case, that on February the 17th, 1966 at 7:01 a.m. in the Eisenhower Suite at Greater Baltimore Medical Center, a male child was born to Rodney and Mary Louise Arthur. It was only when I got my Social Security card, it was only when I got my passport, it was only when I got my clearance that anybody had to make a determination that I was a citizen. So there's a lot of confusion about this. Hopefully this clears up some of the confusion, and when that decision comes down, hopefully I've given you sort of a basis. I think what's going to happen is the court is going to say it's a vague term, subject to jurisdiction thereof is a vague term, and therefore it can be interpreted. But the last clause of the 14th Amendment says, with respect to the implementation of this section, Congress shall issue legislation. So I think that what they're going to find is it's a vague term, it's subject to interpretation. Congress has to act on it, and not the president. Kind of splitting the baby, kind of not. But I think that that's probably the way that they're going to do it, and they're going to remand it for Congress to take a look at. But in any event, I think that's how they're going to come out. I really quickly wanted to talk about the DIGNIDAD Act as well. I know that there were some questions about that. That is the amnesty bill that Maria Salazar from Florida has introduced. Got a bunch of co-sponsors. It's bipartisan. Very briefly, I'm just going to run through this. That law, if passed, would grant first-tier amnesty green cards to about 2.5 to 2.7 million people who were brought to the United States under the age of 18. So about just less than 3 million people will get green cards. But you can simply, there's a lot of wiggle room in the law, and if you want to get somebody to issue an affidavit that says you were here when you were under the age of 19, that's going to be sufficient. Grant second-tier amnesty to around 11.8 million other people. And here's really the impressive part that nobody talks about. That amnesty would extend not just to people who were here, but it would extend to people who were deported ever since the beginning of the first Trump administration. So if you were deported from the United States, you can come back and apply for a green card. Needless to say, I mean, not only mass deportation would be impossible, no deportation would be possible because everybody's going to go out and apply for this. Courts are just going to shut down. But here's the other part that nobody talks about. Talk about the amnesty aspects of this. This law would expand the number of legal immigrants coming into the United States every year by 55%. So we accept about 1 million green card holders every year. This would bump that up to 1.5 million. So over the course of a decade, an additional 5 million people would be able to come into the United States lawfully, not counting all those people who got amnesty, who are then going to be able to apply for their loved ones abroad to come to the United States. So yeah, there's a lot of moving parts on this one. I don't really think it's going anywhere. And the president, and you've probably heard Tom Homan talk about this, there's discussion of amnesty, but Tom's not in favor of it, but a lot of people have the precedents here. I really don't think this is going anywhere, but it's an exceptional piece of legislation. As for after action items, I'm going to take questions in a second. If you want to follow the Birthright case, or you want to follow the DIGNIDAD Act, or you want to follow anything else having to do with immigration, CIS.org. I write a blog about every day. I took one day off this week because my son failed to tell me that his lease was up in Durham, so I had to run 250 miles to go pack up the plane. But in any event, but yeah, about once a week. And we have a staff of writers, and this is going to be the best resource that you can find to really understand what happens in immigration. I try to write in an engaged manner. Sometimes I make it, sometimes I don't. The other thing is to be cognizant of what's going on here in Maryland. Now, again, I live in North Carolina. I still have the Baltimore Sun app on my phone. And during the legislative session, I would have thought that Maryland didn't have any problems whatsoever. Good schools, good streets, no crime. Every article that I saw had the word ICE in it. We're going to bar ICE from detaining people. We're going to bar 287G. Here's the thing. When ICE goes into a prison, when there is a 287G program, the only people they are looking for is criminals. That's the only reason. You go to a prison to find criminals. And if they actually had access to the prisons in this state, to Patuxent and everywhere else, they would be so busy, they wouldn't be going and looking for anybody else. They wouldn't be finding anybody else. And they want to go to prisons because, and I worked in a prison for 8 years when I was a judge, nobody has a weapon in prison. You are screened for weapons. There are other officers around. ICE wants to take you into custody in such a way that they protect the alien, that they protect the officer, and especially that they protect the public, because we want to make people safe. With respect to the detention space, and this one is probably the most exceptional thing, because I know that they're talking about the warehouse in the Hagerstown. I don't know what's going on with that. If ICE arrests somebody in Baltimore, in PG County, or Montgomery County, and they cannot detain them, they're going to want to try and detain them in Baltimore, because that's where the family is. That's where the lawyer is. If they can't detain that person in Maryland, they're going to send them to Texas. They're going to send them to Louisiana. Because Texas and Louisiana and Florida and Indiana and Oklahoma, they don't have any problem offering up detention. Remember when I said that this really only adversely affects criminals? Immigration is not punitive. It is not punishment. Deportation is not punishment. Immigration detention is not punishment. Purely ministerial act. Congress has said these people have to be moved out of the country. That's what we do. With respect to the criminals, in 2018, the Bureau of Justice Statistics did an analysis of 401,398 people who had been released from criminal custody in 2005 in 30 states. Basically, everybody who had been released. And they boiled that down to 67,000 and change who are representative of the whole state. Within 1 year of those individuals being released from criminal custody in 2005, again, this is not aliens or citizens, it's a mix. 44% of those individuals were rearrested again. By year 3, it was 68%. By year 9, it was 89%. Those 401,398 people had more than 2 million new arrests by the end of 9 years. 5 arrests per person. So when you hear Steve Toscano down in Fairfax County, Virginia, when you hear any number of people, including the late district attorney in Baltimore City, talk about, fairness. Fairness means fairness to the innocent. And if you want to punish the innocent and reward the guilty, just block ICE from doing its job. They want those people out of the country. And here's the other problem. Most immigrant criminals commit their crimes in immigrant communities because that's where they live. Most criminals commit their crimes in their communities. So when you release them, and if you're doing it in, because I love the immigrant community, and I do love the immigrant community, it's certainly legal. But if that's the point that you're making, you're not doing any good, because the people that you are harming the most are the victims, the future victims of those individuals who are good. So with that, I'll take any questions y'all have, unless I've gone over. Oh, by the way, I didn't have a PowerPoint, sorry. Louise was like, what do you mean you don't have a PowerPoint?
Mr. Arthur.
Yes, ma'am.
I came here for one purpose. I want to know, where are the United States headed? What can we do to fix the immigration problem? What is the wrong with where it is now, and where can we go to make it better?
It's a great question. And I go back to February of 2024. There was a bipartisan, it was actually tripartisan, because Kirsten Sinema was on the bill, Jim Langford of Oklahoma, Chris Murphy of Connecticut, Kirsten Sinema of Arizona, passed a border bill. We really need this border bill. And Joe Biden and Kamala Harris and the New York Times and any number of other outlets said Congress needs to act in order to secure the border. And you know what happened? Donald Trump comes in, appoints Rodney Scott, who was the CBP commissioner. Anybody ever heard of Rodney Scott? You know why you've never heard of Rodney Scott? Because he did his job. You only hear about people who don't do their job. The number of people entering the United States illegally dropped from about 1.2 million, plus there was a lot of shady other stuff going on, to about 200,000 within, a year of Rodney Scott showing. I mean, it literally just dropped off the cliff as soon as Rodney came in. So yeah, when you enforce the law at the border, you don't need Congress to act because Congress has already acted. And the same thing is true about all other immigration laws in the interior. The laws don't need to be rewritten. They don't need to be reformed or amended. They just need to be enforced. And if they were enforced, they would work. And so to the degree that the president continues to, push enforcement, that Tom Homan continues to build trust, even in sanctuary communities, it's going to be good. But that's really where it's going. Unless the DIGNIDAD Act passes, in which case, catch me after that. So, anybody else?
Well, don't we still have on the books what Kennedy passed, where anybody could come here and then have the chain migration, which is just a nightmare.
That's the Hart-Celler Act of 1965. Hart-Celler is still on the books. And it actually expanded immigration to the United States. As I said, there were about 1 million green cards given out every year. Before 1965, that was close to 50,000. So, and Kennedy at the time said this isn't going to make any change, this isn't going to make any difference to the law. But Kennedy probably knew at the time that wasn't true.
Yeah.
So, but, and Hart-Celler actually has a lot of interesting impacts. So, if you've ever heard of the diversity visa lottery, literally there's a lottery that gives away 50,000 green cards a year. And it gives them out to people from countries that don't actually have a large immigrant influx to the United States. A lot of countries in Africa, a lot of countries in Asia, a lot of countries in Europe, not South America, not Central America. So this is really, if there is one thing that needs to be changed to the law, about 61% of all of the people who get green cards get them because they're related to somebody else. And the analogy has been made, if the incoming class at Stanford University each year was based on who just graduated from Stanford University, it wouldn't take many years until Stanford was around. And that literally is what you have. But here's why it's important. Immigrants in the United States are expected to support themselves. Public charge, it's in the law. If you come to the United States because of who you're related to, there's no guarantee that you're going to be able to support yourself, let alone grow the American economy. The most precious document, not in the National Archives, is each of our United States passports. That green passport is a powerful, blue passport is a powerful document. And yet we literally give it away to people simply based on who the merits is. In his 2018 State of the Union address, the president actually said he would give amnesty to 1.8 million people who would be covered by the DIGNIDAD Act. But in exchange, he wanted the then Democratic-led Congress to switch over to what our allies do, the United Kingdom, Australia, New Zealand, and Canada. They don't have this family-based migration system. They have a points-based system. Now, if you have family, you're going to get points for that. If you speak English, you're going to get points for that. If you have skills that the Canadian, New Zealand, Australian, UK economy needs, you're going to get points for that. But that, family ties are just one thing. And our allies have been doing that for 40 years. And, that's what Trump wants to do. it's it's probably too complicated for this Congress to get around to it, but I think that it will. Yes, ma'am.
Is the United States ever going to recognize dual citizenship?
They do now.
Oh, did it?
Yeah. When I was an immigration judge, I get, as a good federal government employee, I get every other Friday off. It was great. But I would, if you look at the wall, you could picture that, just come up a few blocks to the federal building in downtown Baltimore. And I would go down there 10 o'clock every Friday that I have off, and I would swear in a brand new citizen. Because they like the guy in the room. He just kind of dressed up with them. But anyway, when you become a citizen, when you naturalize, you swear to what's called the oath of allegiance and renunciation. When you renounce your former nationality and all princes and potentates to whom you had previously held allegiance. It's actually a really funny thing. And it's about 900 words long, and my arm would fall asleep because I had to do that. But yeah, no, I mean, if you are, if you are from the United Kingdom, if you're from Germany or Italy or, Ghana or Nigeria or Vietnam, and you take the oath of allegiance and renunciation, we don't take your old passport away. You get to keep it. So you could be a dual citizen, you could be a dual national, perfectly legal, even though you swore to oath.
We have a question here.
Please.
Thank you. I have two questions, hopefully interrelated. Could you give us a snapshot of your typical day when you served as an immigration judge? And also, I hear a bit about the distinction between a judicial warrant and an administrative warrant. Could you address that?
Great question. I would get up in the morning, I'd make coffee. So when I went to work, I worked in New York County Prison. It's right off 83. And I would drive up over the Mason-Dixon line every day. And I would have 20 master calendar cases in the morning. Those would be like 20 arraignment calendars. And then in the afternoon, I would have 2 merits cases. So mostly people applying for asylum, but applying for other things. The administration is expanding that. I mean, 20 was a lot. But they're expanding it to somewhere between 60 and 100 master calendar cases every day. And you figure it's about 4 hours to get them all done. Here's why it's possible. Because out of the 480,000 final orders that were issued by immigration judges last year, 306,000 of them were in absentia, when the alien didn't show up for court. People are showing up for court at levels we've never seen. In fact, I just wrote an article on CIS.org, again, CIS.org/Arthur. I'm giving myself a plug. But talking about the number of people who have filed asylum applications. Now remember, under the Biden administration, 6 million people came in, and the Biden administration treated them all as asylum seekers. Didn't even screen them for claims. In order to get a work document in the United States, you actually have to file an asylum application. 50,000 people last month went into immigration court, called at the border, put in removal proceedings, showed up for immigration court, filed their asylum application, and never went back. They were issued, I think it's 50,000, I gotta think about it. No, it's 8,000. 8,000 per month. It's 50,000 already in the first 6 months. But it's still a pretty good number. So yeah, some of those people that came under Biden truly are refugees, and they deserve refugee status. They deserve to be protected. But nearly everybody else came here to work. And so they played the game long enough to get the work permit, and now they're not coming back. Judicial warrants and administrative warrants. In immigration, an immigration officer, an ICE officer, doesn't need to get a judicial warrant from a judge in order to take somebody into custody. I know that this is an issue here because I've appeared before the Maryland legislature, and they're stupid. But no offense to anybody who's in the Maryland legislature, I'm sure you're good people. But by and large, I went there and you like go to the Judiciary Committee and you get 2 minutes to talk and make your point. I did that. This was the day Chuck Jenkins, who's the sheriff of Frederick County, gets booed and hissed. People are hating him. He does his 2 minutes. And then an immigrant woman who had come for the hearing walks out of the hallway, collapses, and Chuck Jenkins saves her life. I mean, this is a story. But anyway, so I get my 2 minutes, and I go and sit down so I can keep watching. I was the only person in that room that knew what he was talking about. And here's how I can tell you that's true. Because the Democrats on the committee were calling me up to explain things to them. I'm just there, I'm just kind of a guy in the audience. But yeah, and it is a very big distinction. With that, I'm going to actually answer your question. So immigration officers can get an administrative warrant under Section 236A of the Immigration Law. And that is Congress's saying you can arrest somebody based on a warrant issued by various high-level DHS officers. One of the dodges that you see in sanctuary jurisdictions is they say, oh, we're happy to give you our criminals, but we need a judicial warrant. And if you saw Jason Mayares testify before the Judiciary Committee on Thursday, he made a point that I've made. He did it more eloquently. There is no judicial warrant you can get. There literally is nothing that an ICE officer can do to go to a federal judge and get a warrant to arrest an individual alien. So I think that probably 80% of sanctuary jurisdictions are too stupid to know that that's not possible, which means that 20% of them aren't stupid and they're creating an impossibility. They might as well tell ICE, we'll turn over our prisoners if you get us water from the moon or unicorn blood or a decent crab cake outside of Del Mar. I mean, so, it's deliberately impossible. But this is the dodge. And if you go down to Annapolis, I'm sure they'll tell you, oh, we'll do it if you just give us a judicial warrant. Well, how do you do that? Not possible. Yes, ma'am.
Can you give us a spotlight for what it looks like outside of Maryland, or perhaps blue states, and maybe more like North Carolina, and how they're handling the immigration issue?
So North Carolina passed a law that said that you can't be a sanctuary jurisdiction. And Florida and Texas have gone them one better. In Florida, every law enforcement agency is covered by what's called 287G. And 287G is a federal-state partnership where certain state and local cops are trained to spot aliens and authorized to hold them for a period of time till ICE officers can come and get them. So, Ron DeSantis in Florida, he has actually implemented that in the law. Texas has something very similar. They bar sanctuary jurisdictions and promote 287G. They don't really do it like Florida does. Fish and game officers in Florida are 287G officers. And it's actually interesting because probably I did about 20,000 cases when I was an immigration judge. Probably about 500 of them involve people who are arrested for illegally fishing. It's like the craziest thing. You're here illegally, but if you don't know the rules, you figure you can just drop a line wherever you want. But yes, so in about 1/3 of all of the arrests that ICE has made are made in FY 2025 under Trump. We're in 3 states: Texas, Tennessee, and Florida. And so there are this is having a real impact in those states. People are going. But about 45% of the entire unauthorized population lives in a sanctuary jurisdiction. Notwithstanding that, California actually has the highest number of deportations after Texas of all the states in the union. So they're getting around it. California has a law called the SB 54, the California Values Act, which is very, very strict, no cooperation with ICE whatsoever. And we're seeing those laws actually get challenged right now. In Baltimore City, they used to have a rule where if you were a kid who was born on Poppleton Street and you got arrested for a crime, and another guy was born in San Pedro Sula, Honduras, and got arrested for the same crime, that guy from Honduras was going to get more lenient treatment than the kid from Poppleton Street because we don't want to see him be deported. And that was in the name of equity. Because the argument goes, if you're not familiar with the argument goes The kid from Poppleton Street is going to be prosecuted, he's going to be incarcerated, he's going to be released. The kid from San Pedro Sula, Honduras is going to be arrested, he's going to be incarcerated, he's going to be released, and then he's going to be deported. And the argument that they make is, it is a perversion of justice to treat the kid from Honduras different than the kid from Poppleton Street. That's why they won't. That's why they have sanctuary laws. Anyway, anybody else?
Could you give us an update on ICE and how Americans who've signed up for ICE are handling it? There's so much different information.
So, ICE has not had a confirmed director since January the 20th, 2017, when Sarah Saldana, who was Barack Obama's ICE director, left. Joe Biden on his campaign website 2020 said, I am going to appoint a confirmed ICE director within 100 days, and that never happened. The website stayed up for about 4 years until I started quoting it, and they took it down. But so yeah, Todd Lyons is the guy. Todd is a very good guy. Man, I know. I'm not going to say he's my friend because I don't know him that well. But he's a good guy. And he did the job ever since the beginning of the Trump administration. Dave Venturella is the new acting director. He is a guy that I consider a friend that I've known for years. Great guy. I mean, very driven. Morale is good. I mean, everything that's going on, morale is good. Secretary Mullen, Mark Wayne Mullen, came in. He is Undersecretary Noem. They truncated some of the training for young ICE officers. Mullen is doing the full 12 weeks that we've always done. That's probably going to be for the best because you don't want to put untrained people out on the street. It's going to create a danger to the public, and it's going to create a danger for the officer. So, but yeah, I mean, they're going great guns. You know, Tom Homan has the president's here. Tom Homan, you know, has the president's agenda, and I've known Tom for years and years. And what you see on television is exactly that guy. I mean, he's like tough and crusty. I don't understand this, but God, I hope Tom's not watching. But you know, this is the same guy who will start crying when he talks about, you know, a 3-year-old girl that he found at the border when he was an agent who had been raped. I mean, he can't, you know, he's an interesting guy, but what you see is what you get. And, you know, he understands what to do. Dave Venturella does, Todd Lyons. And I wish Todd Lyons all the best because he was very good. But yeah, I mean, things are moving along. But the day that Secretary Noem stepped down, I was quoted in an op-ed in the Washington Post as stating, the American people favor deportation. And I could show you polling that confirmed it. I didn't put that part's up in the quote. They just don't want to see or hear much about it. So, you know, anybody who's been in law enforcement, anybody who's married to a law enforcement person, it's a rough job. I mean, it literally is sausage making. We're glad that people do it. We don't want to see them do it. You know, I'm the nephew of 2 Baltimore City cops. And, you know, I love them. They're great people. I would not do what they do. It's a tough job. But yeah, I mean, they are, you know, we have moved away from flashy videos. I don't know if y'all saw this, but there was actually a tweet that was put out, I think it was in October or September, where they spliced together Pokemon cartoons in immigrant arrests. And I'm like, you know, and I don't know who thought that was a good idea, but it wasn't. Because if you talk to an ICE officer, you talk to an HSI agent, you talk to a Border Patrol agent, this is a serious job. You know, it's not fun, it's not cops, it's not, and you know, they have great respect for the people that they are going after. You know, except if they're hardened criminals, in which case they're still going to treat them right. They just have no respect for them at all. But but yeah, I mean, morale is good, and you know, Mullen is the right man for the job. Tom is the right man for the job. Stephen Miller, understands everything that's going on. Dave Venturella, good guy. So, again, just because you don't see it, it's sort of like God. Just because you don't see him doesn't mean he's not there. Yes, ma'am.
Question. Are you familiar with the ICE facility that was to be built in Howard County? And what do you think the outcome of that? Because they have sued the county.
So, I'm not 100% familiar. We used to, because I was with the INS in Baltimore, and we used to do the Howard County jail. We would keep people in the Howard County jail.
Well, ICE came in and built a facility in Elkridge.
In Elkridge?
Yeah, they were almost ready to occupy it.
Yeah.
The county then decided, no, they didn't want them to occupy. Now the ICE is suing the county.
Yeah, so it's a great question, because one of the interesting things when you talk about ICE detention is that it is the one place, states have nothing to do with immigration. They can help if they want, but they can't make their own immigration rules. And they can't really impede immigration, but they try. And they often succeed when they try. But when it comes to establishing a detention facility, you have to comply with state building codes and state health codes when you do that. So that is the one place, and that is sort of a throttle point for states and localities. But under various interpretations of the supremacy clause of the Constitution, you can't impose restrictions on the federal government that you don't impose on everyone. So one of the things I think you're going to see in a case like that is you're going to see the federal government say, you're putting burdens on us because you don't like the way that we're carrying out this federal activity, and that is improper under the supremacy clause. Because the supremacy clause says the law of the United States is supreme. And so, but again, it gets to the point. We used to hold aliens in Wycomico and in Howard County. And then, all of these laws have gone into effect. We're not going to allow it. We're not going to have cooperation. When Howard County detained people for ICE, Howard County made $150 per bed per day for beds they weren't using. So they could pay correctional officers and they could pay for the upkeep of the facility, money they wouldn't get otherwise. And as I mentioned before, if I arrest somebody on Lower Broadway in Baltimore, if I can place them in Howard County, I will. If I can place them in Wycomico, I will. But if I can't, you're off to Alligator Alcatraz. You're off to Angola Prison Farm. You're off in Louisiana. You're off to, someplace else where you're going to have to find a new lawyer when your family's probably not going to be able to see yourself. It's very short-sighted. Again, these cases are going to take a while, to work their way. But I think that's going to be one of those things where the Fourth Circuit and not the Supreme Court just lays down a marker and says, you can impose reasonable restrictions that you impose on everybody else, but you can't put special restrictions on immigration enforcement when it comes to detention. That's the way of saying we're throwing you out. Hey, listen, it's fine. I don't care.
No, it's my way of saying I'm going to give you a gift.
Oh my God! Thank you
And
so much.
another gift.
Ooh, I like this.
Here you go.
Do I get anything else? Thank you all so
Thank you so much.
Thank you all so much.